Ready, start. As already stated, the ownership continues to remain with the enemy, but the management and the custody of the property only remain with the custodian, and in the absence of the enemy, the custodian is empowered to sell or alienate such property and can issue a sale certificate as is expedient to do so. Full stop. This is in the interest of or benefit of the enemy property. Full stop. Thus, the transfer of such enemy property by sale or otherwise is for and on behalf of the enemy who is not available in the country, and in order to ensure that such property is not dissipated owing to the owner of the property being absent in the country. Full stop. Thus, in order to protect the enemy property, the custodian is empowered to even sell the enemy property and deposit the sale proceeds with the central government. Full stop. The sale or transfer of ownership of the enemy property in favor of the transferee is, in fact, on behalf of the enemy who is the owner of the property through the legal and statutory authority of the custodian, which empowers him to alienate the property for good and sound reasons and in the interest of the enemy property, irrespective of whether there is any claim made by the enemy or his heirs or descendants. Full stop. It is for this reason that the original title deeds may remain with the enemy or his family vis-a-vis the enemy property, and in lieu of handing over of the title deeds of the property to the vendee or purchaser of the enemy property, a certificate of sale is issued in favor of such person by the custodian, and such certificate of sale is a valid instrument for seeking registration of the property in favor of the transferee. Full stop. When the registration of the sale is made in favor of the transferee by the custodian, the latter is acting as a trustee and not as the owner of the enemy property. Full stop. Therefore, it cannot be accepted that the custodian is acting as the owner of the property, and by that logic the enemy property would become the property of the union. Full stop. Further, since the custodian is the trustee of the enemy property, if any monies are due to the enemy, or if any order has been made with regard to enemy property vested in the custodian, which are paid or complied with by any person, as the case may be, and a certificate is issued in that regard by the custodian, such a person, to whom the certificate is issued, shall not be liable to any suit or other legal proceeding, by reason only of such compliance. Full stop. This aspect also indicates that payment made to the custodian is payment to the enemy, enemy subject or enemy firm, who accepts the same for and on behalf of the enemy, and the payer is thus absolved of all his liabilities and obligations to the enemy. Full stop. In Amir Muhammad Khan, it was observed by this court that vesting of enemy property in the custodian is limited to temporary possession, management and control of the property till it becomes incapable of being used by the enemy subject for carrying on business and trading therein. Full stop. This does not divest the enemy subject of his right, title and interest in the property. Full stop. The aforesaid two aspects are totally distinct. Full stop. However, in the said case, this court has observed that on the death of the enemy subject, the said property would cease to be enemy property if the same is succeeded to by his heir who is a citizen of India. Full stop.